today. The first case is case number C200011, Marcus Fontaine versus Harjinder Sandhu. If counsel could please identify yourselves and your readiness to proceed.
Ma'am, my name is Marcus Fontaine. I'm the plaintiff in the case.
Okay, good morning, Mr. Fontaine.
Good morning.
Well, good morning, Your Honors. I'm Brian O'Connell. I'm representing H&R Cincy Properties, Harjinder Sandhu, Jasreen Sandhu, and in a first, also representing myself.
Okay.
Morning, Your Honor. Zach Prendergast. I am counsel for defendants Appellee's Prodigy Properties LLC, Jeffrey Lane, April Lane, and myself.
Okay. And how are you gentlemen going to be splitting time?
Mr. Prendergast and I have discussed that. I will go first, and I will use 10 minutes, and then Mr. Prendergast will be back and clean up in the last 5.
All right. Thank you very much.
And Your Honor, I would like to have 10 minutes and reserve 5 for rebuttal.
Okay, that was my next question. You took the words right out of my mouth. All right, so Mr. Fontaine, so you've got 10 minutes, and then the attorneys, they will be making their arguments, and then you will have your 5 minutes in which you can respond to anything that was raised at that time. Okay.
Thank you, Your Honor.
You can start whenever, we can start whenever you're ready.
Thank you. If I may, I would like to read some notes that I have made regarding the case so that we can keep the dates in the proper perspective.
That whatever you would like to do, we are fine with.
Thank you. So I'm just going to read from what I wrote. This is a breach of contract case stemming from the dismissed case, H.R. Cincy Properties, case number A170564, and the resulting damages from the breach. This case is intrinsically, or this appeal is intrinsically connected to that case. In fact, that case should have been consolidated with this one, but somehow it didn't happen despite the motions that were filed. When I refer to Mr. O'Connell, I am including his co-defendants, his clients, and the same thing when I refer to Mr. Pendergrast, I'm referring to his clients, which are also his co-defendants. On April 3, 2019, I filed my second amended complaint in this case, subject to this appeal. The events complained in my lawsuit relate to matters that happened in that case, in the H.R. Cincy case, in the other court, after February 11, 2019, when the receivership was supposed to be ended. The dismissal of the plaintiff lawsuit in this case was strictly based on matters related to that other case in the court of Judge Nestor, where the plaintiffs, post-dismissal of that case or post-dismissal of this plaintiff, created a receivership action commencing sometime in January of 2019, about a month before the receivership was to be ended.
Well, it was an extension of the receivership. Is that correct?
The extension of the extension of the receivership was an improper extension because Judge Nestor, the newly newly elected judge, did not have jurisdiction to entertain anything post-dismissal. We were dismissed on September 26, 2018 with prejudice. So anything that happened after the February 11, 2019, Judge Nestor conducted without jurisdiction. As a matter of fact, this court on February 26, 2021, on appeal number C190574, dismissed that case, dismissed the judgment that Judge Nestor issued against the dismissed defendant, including myself, on the grounds that the court did not have jurisdiction over the dismissed defendants to enter any judgments.
There was still a defendant left in the case, though, and I don't think this court ruled that. There was one defendant that was remaining. You were dismissed.
right, the defendant.
There was still a case pending before Judge Nestor.
No, ma'am, let me explain, because I have watched the oral argument. The reason why Sinvexco in that case remained a defendant is because Defendant O'Connell did not officially dismiss the defendant. In the settlement agreement that was entered on August 21, 2018, Sinvexco was supposed to be dismissed on February 11, 2019 by Defendant O'Connell. He did not do that precisely because he wanted to continue the case. The settlement agreement is on file in this court on the docket TD 119. And if I may, I would like to continue with some of the dates. On October 31, 2017, H.R. Cincy and Harjinder Sandhu sued the plaintiff and others. On August 10, Judge Martin ordered the appointment of a receiver. That will be TD 145, I should say. On August 21, 2018, the parties executed a settlement agreement where the receiver agreed to end the receivership on February 11, 2019 in exchange for $11,000, which is a legally binding contract and a binding promise. This is the settlement agreement, TD 119. In this settlement agreement specifically says at 5 that Defendant O'Connell on February 11, 2019 to end the receivership and enter the final entry of dismissal, he was supposed to dismiss Sinvexco. Instead, because they wanted to continue the receivership, he did not dismiss Sinvexco so that it could be used as an excuse to continue the receivership. But that didn't matter anyway, because Judge Nestor did not have subject matter jurisdiction or in personam jurisdiction, as you already ruled. On February 26, you already ruled that Judge Nestor did not have in personam jurisdiction over any of the dismissed defendants. Sinvexco, it's just another. The fact that Defendant O'Connell did not dismiss Sinvexco doesn't mean that it was not part of the contract. And let me say this, I was not involved in those proceedings in the beginning because I was completely shut out of the case. Judge Nestor on February 7 at a hearing even threatened me to incarcerate me if I attempted to appear pro se in the case. So I had no way of defending this. So this is my first chance to really defend the case. So on August 21, we entered into the settlement agreement. The receiver agreed to accept $11,000 for the receivership, for 6 months receivership from August 10 through February 11, 2019. Subsequent to that, on September 20, the payment to the receiver was made for $11,000 by the defendant's counsel. On September 26, Defendant O'Connell executed at page 2 of the agreed entry of dismissal, TD 118. This is his signature on the back of that, on the second page. He executed the agreed entry of dismissal.
Mr. Fontaine, just to let you know, your camera is off, so it's.
I'm sorry. Was it off all the time?
It was off all the time.
I'm sorry.
People appear off, so to me, it wasn't anything unusual.
Oh, no, not at all, not at all. On the same day that Defendant O'Connell executed the agreed entry of dismissal, Judge Martin issued the final judgment dismissing the dismissed defendants, including the plaintiff. And if you read the final entry of dismissal, it specifically says that on February 11, the receivership was to end and everything was to be terminated, including the dismissal of Sinvexco. But I could not force Mr. O'Connell to dismiss Sinvexco. I mean, no one could. And the attorneys that we had at the time, Lord have mercy, they're the best money a poor attorney can buy, or vice versa. Post-dismissal of the plaintiff in the H.R. Cincy case, commencing January 11, 2019, in the court of the newly elected judge, Terry Nestor, they began a receivership action against the plaintiff and the dismissed defendants. only that we were not allowed to argue in that receivership action. We were completely thrown out of the courtroom. We were not to participate in such receivership action,
Well,
right?
They continued the receivership, and you were a dismissed party with no standing, and so that's why you weren't allowed to participate.
That is correct. Exactly correct. So they continued a receivership action against the dismissed defendants, which were not present in the courtroom, right? In a court that did not have jurisdiction over the case to begin with. In fact, the Hamilton County Court of Common Pleas lost jurisdiction over the entire case the day that Judge Martin entered the final judgment of dismissal. That was the end of that case, right? So the acts taken
So
in the court of Judge
are
Nestor.
you saying that the court didn't have authority to enforce that particular order?
Oh,
after
yes,
conferring?
Your Honor. Good point, good point. The only power Judge Nestor had was to enforce the final judgment. He did not have any power to enforce the settlement agreement because the settlement agreement was not incorporated into the final entry of dismissal. And that was discussed at the oral argument in the H.R. Cincy case on January 19, 2021. This was thoroughly discussed at that time. Judge Nestor did not have the judicial power to entertain the settlement agreement because it was not included in the final judgment entry, right? So what happened here?
You did have power on the receivership, though.
If the final judgment entry divested the court, the Hamilton County Court of Common Pleas over the case, Judge Nestor did not have power over any receivership.
If we agree with you that that entry divested the court of jurisdiction, then maybe. But if it did not divest the court of jurisdiction, then he did have power over the receivership.
The receivership was ordered right here. The receivership was ordered by Judge Martin to end February 11, 2019. Judge Nestor did not have jurisdiction to entertain any receivership, but be that as it may, I was a dismissed defendant and they continued a receivership.
I'm just letting you know that you have an hour left, a minute left.
Okay, let me make it quick. So they fabricated a receivership action, and that receivership action is thrown out everywhere all the time. In the receivership action, Judge Nestor issued a judgment against the plaintiff for $79,000, right? Which is TD 135, by the way. All of that was in breach of contract. We had a contract that said that you were dismissing me from the case, the plaintiff, that you were not going to bother me anymore, the plaintiff, that you were not going to come after me, the plaintiff. That's a contract. And contracts are enforceable. One more point. Defendant Pendergrass will come here and say, oh, but I was a receiver. I was representing the receiver. I didn't sign the contract. Wait, they collected the money. The receiver collected the money. He represented the receiver during the negotiations of the settlement agreement. They collected the $11,000. So he cannot come and say, oh, there was no contract. In Ohio, an oral contract is an enforceable contract. So basically what happened is that
So
here,
Mr.
this
Fontaine,
case.
I'm going to go ahead and reserve your 5 minutes, okay?
Thank you.
Thank you. Counsel?
Thank you, Your Honors. It's hard to know where to begin, but let me begin with this. The fact that a litigant doesn't like the result reached or the judgment entered in one lawsuit does not afford the litigant the right to initiate a separate common pleas action in an effort to change the result reached in the first case. The proper remedy.
Ultimately, his
is the
argument
Court
is
of
that there was a
Appeals.
lack of jurisdiction. So he's doing a collateral attack based on lack of jurisdiction. How would you respond to that?
Your Honor, there was in fact jurisdiction over Mr. Fontaine. That exception is very limited. The case law is very clear that collateral attacks are disfavored and should be looked at very narrowly. They will be permitted where the defendant or the plaintiff in the subsequent action is has not been served, and the court never had jurisdiction. In fact, every case you'll see that exception applied will be where the court never had jurisdiction over that party. The phrase that the courts use is to refer to the person as a stranger to the lawsuit. Your Honors, you cannot conclude that Mr. Fontaine was a stranger to this lawsuit. He was represented by counsel. He was served. He was represented by counsel. He appeared in the action. In fact, even after he was dismissed, according to him, in September of 2018, between that point and February of 2019, Mr. Fontaine filed no fewer than 25 pleadings in the case. Moreover, as this court knows, he appealed this. He appeared via counsel in the action, briefed issues after February 11th, appeared in the action. When the judgment was entered, he appealed it to this court. And now the court has remanded the case back to the trial court for recalculation of damages. So at this point, he is evidently, once again, a party to and subject to the court's jurisdiction in that case. All of this underscores what Mr. Fontaine is trying to do here, which is to create lawsuits about lawsuits. His remedy was in the Court of Appeals. He exercised that, and it should not be permitted that a person simultaneously undertakes a collateral attack in a lawsuit and a direct attack through an appeal. Collateral attack is reserved for situations where there is no opportunity to undertake the direct attack, such as where the person was never served and never had jurisdiction. The court never had jurisdiction over that. One other point I did want to make is,
Well, before you go there, the other
Yes.
argument that he makes is that the February 11, 2019 order, that at that point that divested the court of doing anything further with regard to the defendants.
Well, it's actually a little confusing for me to understand that, in the sense that his counsel continued to represent him in that action after that time, and he has subsequently appealed for the action since that time. If he had an issue with what happened after that date, he had every opportunity to raise that on appeal, and he has. In fact, he raised the issue on appeal, and the court has remanded on that basis. So,
To be clear, the only thing that he raised and was remanded was the issue of saddling him with court costs for the receivership after February 11th. It wasn't about damages. It wasn't about. He tried to file motions and was not allowed because he had been dismissed, right? So court costs was the only issue in front of this court.
well, it was the only issue that he raised, and that's to my point, that if he had other issues, it was incumbent on him to raise them, or they were waived. And in fact, he did. If you look at the docket from that case, his counsel did, in fact, continue to file on his behalf after that point, including filings on the allocation of the fees. That was briefed on his behalf by his counsel after February 11th.
Now, he also argues that the court didn't have authority to enforce the settlement agreement because the settlement agreement was not part of the order, was not written into the order. How would you address that?
Well, the fact of the matter is that I argued that the court in the prior case, I argued that the court did have that jurisdiction because the parties agreed to that. And there is authority, the fact that where parties, by virtue of a party's actions, a party can again submit themselves to personal jurisdiction in front of the court. But the fact of the matter is that if that were in fact what the issue that he had every opportunity to file a motion to intervene in the case in order to re-interject himself into that and enforce the settlement agreement. One item I did want to mention to the court is that since the briefs were filed in this case, Mr. Fontaine has filed yet another collateral attack on this case.
Well,
on the
that's not part
receivership
of our
action.
record.
It's not, but I think it's worth mentioning. And the other cases he's filed.
I understand, but it's
mentioned.
not part of our record and we should not even be considering that.
All right. Well, be that as it may, I think there is, it goes to the fundamental problem here of allowing these collateral attacks, especially ones that are brought not only against parties to a lawsuit, but against their counsel.
Can I ask a question? So
Sure.
my understanding is that there was one defendant that was left, and every other defendant was dismissed. So we have, was it Convexio or
Sinvexco.
Sinvexco? So do you believe that the defendants that were dismissed, like Mr. Fontaine, should have been able to argue against the extension of the receivership, even though they were dismissed? Because the judge wasn't, he said, you're dismissed, you don't have standing. And of course, that was not appealed. You're right, that was not appealed to this court. Do you believe that those dismissed defendants did have standing to argue against the extension of the receivership?
I believe, yes, they could have. And the right mechanism would have been to intervene in order to do that. Let me just make a couple other points about the other issues that had been raised by Mr. Fontaine in the case. One is that the court impermissibly converted the motion to dismiss to a motion for summary judgment. I think it's clear that that did not happen. Judge Cooper ruled on it as a motion to dismiss. And even if she had chosen to rule on it as motion for summary judgment because we filed in the alternative, that was permissible and no notice was necessary. He also raised the issue of Judge Cooper relying upon pleadings in other cases. Mr. Fontaine cites some 4th District Court of Appeals cases from 1990s for the proposition that a motion to dismiss, court cannot take judicial notice of pleadings in other cases. That case law is simply outdated. The more modern trend with the advent of the internet, and this is supported by both the 1st District Court of Appeals and the Ohio Supreme Court, is that the court can take judicial notice of filings in other cases, as Judge Cooper did here. The other issue that he raises is that the Judge Cooper failed to rule on several motions and failed to grant an extension of time or hold hearings. Response to that is twofold. First, that any motion not ruled upon is considered to be denied, and the decision to grant an extension or hearing is within the court's discretion. I'm told I have just about a minute left, and I wanted to make one final comment to the court about some of the less than generous comments that Mr. Fontaine has made about me in the filings in this case. Just to give you a few examples, he said defendants O'Connell and Prendergast, who have an uncanny ability to con a judge and to corrupt any judge willing to play their games, that defendants Prendergast and O'Connell represent a clear and present danger to the public. They are true definitions of a menace to society, and that they lie like most people breathe. The reason I mention all of that is, and I can, I've been doing this long enough. I can take it. As defamatory as that is, after a while you learn to roll with it. But what I think needs to be addressed here is the bigger concern about the precedent that would be set if this dismissal is not affirmed. It would set a dangerous precedent where, again, and this was, I think, apparent from the oral argument from Mr. Fontaine. He wants to have a lawsuit about lawsuits and about what the counsel did and what the judge did. Because bear in mind, everything that he bases his claim on isn't just unilateral action.
Aren't we just ultimately bound to whether it's a proper collateral attack or not?
Yes, that is correct. And as I pointed out, the fact is that every case that has found the jurisdictional exception has been based on either a complete lack of subject matter jurisdiction or a complete lack of personal jurisdiction over the person. Every one of those cases involve situations where the court never had jurisdiction over the defendant, where the defendant was in fact a stranger to the action, where he was not served. Again, it cannot be said that Mr. Fontaine was a stranger to this action. He did not have it. He had his day in court, and he had his opportunity to take that issue to the Court of Appeals, which he did. Given that this is a classic example of a collateral attack, the underlying public policy is just too important here to be ignored. We would ask that the court affirm the dismissal of the complaint filed by Mr. Fontaine.
Thank you, Attorney O'Connell. Attorney Prendergast?
Hi. Good morning, may it please the court.
Good morning.
Just to quickly clear up a sort of a factual or sort of a false factual allegation here. Mr. Fontaine references this settlement agreement and alleges us of being a party to it, of negotiating it. The receiver and no party of the receiver had anything to do with this settlement agreement. We are not a party to any settlement agreement. We did not participate in negotiating any settlement agreement. There is no evidence in the record to the contrary. You will not see a signature of any one of us on that settlement agreement. It has nothing to do with us. My client was a court-appointed receiver. We were appointed pursuant to orders entered by Judge Martin and then entered again by Judge Nestor. And that really goes to the heart of the matter that was the grounds for our dismissal here, is that in the state of Ohio, the law is clear that one cannot file a lawsuit against a court-appointed receiver without obtaining leave of the appointing court. And pretty much what happened here is that Mr. Fontaine has an axe to grind about orders that were entered by Judge Martin and entered again by Judge Nestor, and he's decided to take that venue in front of Judge Cooper instead of litigating it back in front of the originating court here. And I have cited the case law in this. I think this is pretty clear. The reasons for these protections are very clear. There's really no issue. I know he makes some hay in his reply brief about, these are issues that were outside the brief. He attached all of these receivership filings and pleadings to his complaint, the order appointing receiver, the order extending the receiver, even to his brief, he even attached the September 12th, 2019 order in which Judge Nestor basically said the receiver did everything it was supposed to do. The receiver is completely exonerated. All the receiver's expenditures, actions, were completely approved, and he appealed that.
Was that determination of fact challenged on direct appeal?
I'm sorry?
Was that determination of fact challenged on direct appeal?
Yeah, he did have counsel that appealed that termination, and they appealed it on the very
Let me
limited.
clarify my question. The determination that the receiver had acted in good faith?
No, actually, that issue was not appealed. The only issue that was appealed was the allocation of the receiver's fees and costs. And this court has already passed on that. They remanded it to Judge Shanahan to recalculate those costs. And Judge Shanahan is going to hear oral arguments on that next week. That was the only issue that was appealed from the order. So right now there is an order on that's unchallenged that said the receiver in this case did every single thing that it was supposed to do. However, Mr. Fontaine wants to relitigate that in front of this court, in addition to the federal district court, in addition to the Warren County Court of Common Pleas, in addition to the municipal court, all these other places where he's filed lawsuits against us. And really, this is, I'd say, as somebody who represents receivers on a regular basis, this is a textbook case of why this protection exists. Because essentially, a receiver is appointed by the court. He's a servant of the court. He does everything at the direction of the court. However, he becomes a lightning rod for litigants with axes to grind who decide that they want to harass and basically use the machinery of the judicial system to settle scores. And in this case is particularly egregious because not only did he sue the principal of the company and his counsel, he sued my client's wife. Now, I mean, I don't want to get emotional in this hearing here, but I mean, how this could possibly be allowable without even going through the simple gatekeeping function that is set up by Ohio case law. It just can't be allowed, because that, to me, that sends a message to anybody who's willing to act as a receiver or a special master or a private selling officer, anybody who's willing to serve the court in a statutory capacity, that you can do this, but the court's not going to protect you if somebody decides to file half a dozen frivolous lawsuits against you and tie you up in court for the next 2 years. So the case law is really clear. And I think the court's choice here is really clear that, Judge Cooper decided to dismiss this case because Mr. Fontaine didn't even go through the simple requirement of asking the leave of court that's required by Ohio law. So I would just ask that the court, affirm Judge Cooper's decision to dismiss this. If he wants to go back to Judge Shanahan and ask her for permission to sue us, he can do that. He can absolutely do that, but he has not done so in this case. So Judge Cooper was absolutely right to dismiss this. And I just ask this court to uphold it. Thank you.
Thank you. Mr. Fontaine, you have your 5 minutes.
Thank you. That dissertation that they both made is absolutely fraudulent. And let me say why. In the settlement agreement, I paid them, the defendants, $35,000 to stop the receivership on February 11, 2019, of which $11,000 went to the receiver. Of course, the receiver's signature is not on the agreement because the receivership is an ancillary to the case in chief. What they did after February 11, after Judge Martin ordered the receivership to end on February 11, what they did is they fabricated a receivership action in the court of Judge Nestor. So everything that they're talking about is a fabrication in the court of Judge Nestor. Now, Judge Nestor did not have the power to enforce the settlement agreement, and Judge Nestor did not have the judicial power or constitutional ability or whatever it may be to overwrite the final order, judgment order of Judge Martin. What happened here is that they went to Judge Nestor after Judge Nestor became a new judge, and they went there and they said, Judge, let's just fabricate a receivership action and let's keep them out and let's get a judgment. Eventually, what happened is that we ended up with a judgment for $79,000 from the fake receivership action. Now, none of the things that happened after February 11 should have happened. It was a breach of contract. They made a contract. I'm suing them for breach of contract. I'm not suing them for anything else. And so that I can answer Mr. Pendergrass, in the settlement agreement, in this contract, I fired him effective February 11, 2019. He was fired. In the final judgment, Judge Martin fired Mr. Pendergrass effective, really, because they were working for the court. Judge Martin fired him effective February 11, 2019. So what they did is, in a roundabout way, they went to Judge Nestor, who did not have jurisdiction over any of the dismissed defendants, who did not have jurisdiction over the case, and where, because of the final judgment entry, the Hamilton County Court of Common Pleas did not have jurisdiction at all, zero jurisdiction. So here we have Judge Nestor did not have jurisdiction. The court did not have jurisdiction. Judge Nestor didn't have in personam jurisdiction. Judge Martin ordered the receivership to end on February 11. Judge Martin fired the receiver effective February 11. I fired the receiver effective February 11 after paying him $11,000. So what we have here is a case of breach of contract, and anything else that they're talking about is for another time. It has nothing to do with this case. All of this thing about the receivership that cannot be sued. Well, let me ask you this. After Judge Martin fired them, after Judge Martin fired the receiver, why did they go back to Judge Nestor in violation, in breach of the settlement agreement, and fabricated a receivership action? When this case began, it began as H.R. Cincy Properties versus Marcus Fontaine. It didn't begin as receivership action versus Marcus Fontaine. The receivership was appointed by Judge Martin on August 10, 2018. And Judge Martin said, ended February 11, 2019. It doesn't say maybe, it doesn't say perhaps. This is not an order that you can say, well, it's ambiguous. No, it's not. It says ended, right? The settlement agreement. This contract here says ended. Here is the money to end it. Go away, leave me alone. They didn't. Until today, and he talked about the lawsuit that we have pending in Warren County. You know what they did? They filed 4 fake certificates of judgment lien. Okay.
This is not before us.
I can appreciate that, but he mentioned it, by the way. What they have done is unconscionable. They have dragged me through the mud. And Defendant O'Connell talks about me calling them a con man or whatever. You know how many times they have called me a convicted felon? 71 times. They have called me a vexatious litigant more than 60 times. I am not neither a convicted felon nor a vexatious litigant. These people,
Just to let you know, you have 1 minute, okay?
thank you. Going back to the case. This is a contract. They breached the contract. Whatever excuse they have, they breached the contract. This is a final judgment order by a judge, by the judge presiding at the time we made the contract. And the judge said, you end the receivership on February 11th, end of story, and you dismiss in vexco. Now that you mention it, dismissed in vexco. So anything else that happened after February 11, 2019 was breach of contract. Nothing to do with collateral attack, nothing to do with any of that. I am demanding breach of contract. And the damages as a result of the breach of contract, which are probably right now in excess of $1 million, excluding $100,000 in legal fees that they have made me spend fighting them, trying to stop them from continuing their malicious litigation against all of the dismissed defendants, including my family. So going back to this is a contract. I'm suing them for breach of contract, nothing else. And Pendergrass.
Understood. Okay, thank you, Mr. Fontaine. And thank you everyone for your arguments this morning. I know this is a very important case to everyone here. We will take the matter under submission and issue a timely decision. And Mr. Fontaine, if I can take a second to confirm your mailing address, okay? I have it as 9378 Mason Montgomery Road. Is that still it? Number
Yes, it is.
425, okay. 45040, okay. And if for some reason there's a change of address, just let us know. That way, anything that we send, you'll be able to receive it at the proper address.
Thank you, Your Honor.
Okay, thank you all for your arguments again, and I wish everyone a wonderful afternoon.
Thank you, Judge.
Thank you, Your Honors.
Thank you.
Close the here, yeah.
Good morning.
Morning, Your Honor.
Good morning, Your Honor.
Good
Good morning.
So we're here now on the case number C200275, which is State of Ohio versus Jacob A. Miller. If attorneys can please identify themselves and their readiness to proceed.
Sure. Mark Epley on behalf of the appellant Jacob Miller, and we are ready to proceed this morning, Your Honor.
Good morning, Attorney
Morning.
Epley.
Thank you.
Chris Conitzer on behalf of the city, plaintiff Appealable, and we are ready to proceed.
Good morning, Attorney Conitzer. So Attorney Epley, would you like to reserve time?
Your Honor, if I could please reserve 3 minutes of rebuttal time, I'd be appreciative.
No worries.
Thank
Easy
you.
peasy.
Thank you, Your
Whenever
Honor.
you're ready.
Thank you, Your Honor. Good morning to this honorable court and to opposing counsel. Mark Epley on behalf of Jacob Miller, the defendant and also the appellant in this case. This case presents two issues for this court to decide, both of which are based upon the abuse of discretion standard. The first issue for this court to decide is whether or not it was an abuse of discretion for a court to sua sponte make its own motion to withdraw a guilty plea of a defendant. The second issue before this court is whether or not that withdrawal of the guilty plea by the court now subjects the defendant, Mr. Miller, to double jeopardy under the U.S. Constitution, Fifth Amendment, and also under the first section of the Ohio Constitution, Article 10. On December the 12th, 2019, Mr. Miller entered a guilty plea. The court accepted that guilty plea after Rule 11 of the Criminal Rules of Procedure was followed. In essence, what Mr. Miller did was plead knowing full well that he had the right to counsel, that he had the right to a jury trial, that he had a right to cross-examine witnesses, and some subsequent motions as well. What happened was that the court accepted Mr. Miller's guilty plea and set the matter for sentencing on January the 14th of 2020. On January the 14th of 2020,
How is it reflected within the entries of the court?
the entry finds that there was an amended charge that was offered by the prosecution, and as such, there was a plea of guilty. That's all that was entered on December the 12th of 2019, Your Honor.
Okay, and what does the
let me-
transcript reflect? I'm sorry.
No, go ahead, Judge.
Okay, and what does the transcript reflect?
The transcript reflected on page 5 of December the 12th that there was an entry finding Mr. Miller guilty of disorderly conduct, which is a misdemeanor of the 4th degree, Your Honor. As such, on January the 14th, the court, let me back up. The court also entered and said that on January 14th, the case would be continued for sentencing. On January 14th, the sentencing date came about, and that case was continued until January 31st on the issue of whether or not restitution was appropriate in this case. On January 31st, the court decided on its own motion to withdraw Mr. Miller's guilty plea, having absolutely no motion before the court other than its own motion. Mr. Miller never filed.
What prompted that? Why did the court do that?
The court, it's my understanding through the transcripts that the court believed that the charges that Mr. Miller pled guilty to on December the 12th of 19 did not meet the elements of the actual first degree misdemeanor to which Mr. Miller was charged back in July 27th of 2019. So the court in essence didn't feel that the plea of guilty to the disorderly conduct misdemeanor 4 actually met the criteria for the assault that Mr. Miller was originally charged for back in July of 2000.
But what changed between the time that he presumably accepted the guilty plea to the sentencing when?
So my understanding is that there was a second victim impact statement that was rendered by the victim in this case, and that in essence is what prompted the change of the court to now enter a motion or a vacate of the guilty plea of Mr. Miller.
But I thought the victim was okay with the plea.
It is, Your Honor. It was actually it was okay with the plaintiff or the victim on December the 12th, 2019, when the victim herself actually had an advocate on top of the prosecutor's office. The prosecutor's office actually entered and requested an amended charge from the M1 assault to an M4. And in fact, that was what prompted Mr. Miller to accept the guilty plea. But then also on January the 31st of 2020, the court made very sure that the victim was understanding of what the guilty plea entailed, what the punishment would be for Mr. Miller as a guilty plea. And the victim not only took time to speak with the prosecution now for a third time that day, but also went on to record and agreed that that is what she wanted to do in this case, and that she was fine with what the punishment would be for Mr. Miller under a 4th degree misdemeanor or a 4th degree misdemeanor disorderly conduct, not necessarily assault. After all of that was put onto transcript, at that point in time, that is when the Honorable Judge Berkowitz vacated Mr. Miller's guilty plea and then set the matter for trial. Obviously, because of COVID, that trial got pushed out to July the 28th of 2020. My client on that date entered a no contest plea, at which point in time now the court found Mr. Miller guilty now for the second time of the same events, of the same, I guess, issue that brought rise to the initial charge of the assault, which leads us into the idea of double jeopardy under the Ohio Constitution, Section 1, Article 10, and also the U.S. Constitution under the 5th Amendment. Because it's the same set of facts that brought rise to the two charges, initially the one charge, and then a guilty finding of the disorderly conduct 4th degree misdemeanor, and now also the same facts and circumstances which brought rise to the guilty finding of the judge and the municipal court on the assault back in July of 28 of 2020. That's now prompted the double jeopardy issue.
But with regard to the plea agreement,
sure,
judges are allowed to preserve accepting the plea until they get additional information. Oftentimes they do that and wait to get the pre-sentence report or victim impact statements to determine if they believe they're going to accept the plea. So why is that not what happened in this case?
The court did accept the plea on this. The court made a finding of guilty. They actually, in their own transcript, say that we accept the plea, and that's verified through a number of different matters. Number one, it's verified through the court docket, which now, when you look at the charge on top, it states instead of assault, now it's disorderly conduct. It's also verified and proven through the transcript that he accepted the plea because he sent the matter out for sentencing, which is appropriate under Rule 32. And then the third thing that it did is if the court in its own finding of guilty back in December of 2019, why now are we now filing a motion on the court's own behalf? Why would the court have to file its own motion to vacate a guilty plea if it was already entered appropriately? So the court already accepted, knowing full well that this matter was going to proceed to sentencing. And at that point in time, under Rule 32, and also under the State versus Bomberger idea, I believe it's Bomberger, the idea of Criminal Rule 32.1 states a defendant, Mr. Miller in this case, has the right to motion the court to vacate his guilty plea. But at no point in time,
Mr.
yes,
Epler,
Your Honor.
let me just stop you there because
Sure.
I have to say I've never seen this before, but I took a look at Rule 32.1. It's very short. It says a motion to withdraw a plea of guilty or no contest may be made only before sentence is imposed. And then it goes on to say, but to correct a manifest injustice, the court may after sentence. So this is pre-sentence, and there's no reference in the first part of Criminal Rule 32.1 to who may withdraw that plea. And it's always been my experience that it's the defendant that wants to withdraw the plea, not the judge, but there's no reference to the judge sua sponte can't on its own motion, if for the reasons stated, decides to withdraw the plea. And that's my question. I just have not seen this before, but is there something in Rule 32.1 that would prevent the court from withdrawing the plea prior to sentence?
So I don't think the answer is actually found in Rule 32.1. I think that the answer is found in the case law that addresses the issue of 32.1. For instance, in State versus Millhouse, it says, our review of the Ohio Rules of Criminal Procedure reveals no provisions which would suggest that a trial court should sua sponte vacate a guilty plea once it has been accepted. You also have Cleveland Heights versus Fernando citing that there's no finding that there is a provision in the criminal rules for a defendant. There is a finding of a provision in the criminal rules for a defendant appellant to withdraw, but there's no similar provision for a court to sua sponte withdraw. And you're absolutely right. A majority of the cases regarding a vacate of a guilty plea are brought by the defendant, and those are what gets raised on an appeal. What you have here is a sua sponte motion, as you addressed, and there is nothing in 32.1 which prevents it, but there is case law which strongly suggests that the court should not be doing so. And then you also have the State versus Longnecker issue, which states that the court should, once a guilty plea is accepted, should proceed to sentencing. And I believe that the reason that is there for the court to not be able to sua sponte make a motion on its own behalf to vacate a guilty plea of a defendant is because now not only if the court has that ability and the court has that power, not only have you had the court become the proverbial judge, jury, and executioner, now you allow the court to play defense counsel in and of itself to what they believe is in the best interest of the client, not necessarily the defense counsel that's representing him. And if you do that, then there is power that can only be put into the court and which there is nobody that can defend against it. And I
So
think
you said that this is, earlier you mentioned that this is rooted in double jeopardy and issues of double jeopardy.
correct.
So how does double jeopardy play out when you're looking at it from the perspective of the defendant taking action versus the court taking action?
I believe that's a great question. And I believe the answer comes in this. When you have a defendant who voluntarily and makes that own motion for them, they in essence are saying to themselves, I'm asking to withdraw a guilty plea, knowing that I could be subjected again to the first initial charge before I pled guilty. It almost reverts back as if there were no charge or if there were no plea to that charge. That is a voluntary decision that is made by the defendant. When you have a situation here in which you actually have a charge in which the defendant has already pled guilty, And now you have a court which is deciding that that vacating of the guilty plea is acceptable. Now that is being taken out of the voluntary will of the defendant to subject himself now to an additional charge. You have now subjected the defendant to an additional charge based upon a court's finding, not based upon a voluntary decision of the defendant, knowing that they could be subjected again to additional punishment on an additional charge or on the same charge to which they have already pled guilty.
Mr. Epley, though,
Yes, sir.
doesn't jeopardy attach at the point of sentence?
That is correct. Double jeopardy attaches at the point of sentence under the rule. I understand. The issue that you get is that you have now found a defendant guilty twice of the same actions and the set of circumstances which cause rise to that action. That's the problem with this. You have two.
I'm sorry. The first
Good.
action, there was never any jeopardy because he wasn't sentenced. I mean, he couldn't. Your client couldn't have appealed his no contest plea to this court because it was not a judgment prior to sentence. Say, for instance, your client determined that it sounded like the judge was getting ready to do what the judge ultimately did and filed a notice of appeal on the inclination that the judge was maybe going to withdraw the plea. That's not a final order, is it?
It is not, and that is why the court correctly ruled that our first appeal in this matter was not a final appealable order. The issue with the no contest plea becomes a final appealable order, which is what is being brought before the court.
Right, I understand, yes.
Yes, Your Honor. That's why the court didn't go forward with the initial one, because after the vacating back in February of that, that's when the initial appeal came forward. But without a sentencing, there was no appeal because it was not a final judgment, Your Honor. That is correct.
Thank you, Attorney Epley. I'm going to reserve your 3 minutes.
Thank you, Your Honor.
Okay. Attorney Conitzer, good morning again.
Morning, Your Honors. And may it please the court. Our argument in this matter really comes down to just kind of two essential pieces of how our court system works. The first one is that the court speaks through its entries. Mr. Epley is correct. In the transcript, I believe it was on December 12th, when Judge Berkowitz took that initial amended charge, the plea to the disorderly conduct. He did go through the colloquy on the record, did make an oral finding of guilty. Importantly, however, if you look at the judge's sheet from that date, it simply indicates guilty plea. That's it. It does indicate the amendment as well. On the reverse side, where there's the area for the plea, the finding, and the sentence, that is blank on the judge's sheet from the 12th. And for us, from our standpoint, that means that he had taken the plea, set it out for sentencing, but he hadn't fully accepted it yet. Again, speaking through its entries.
He didn't advise the defendant about that, though.
I'm sorry?
He didn't advise the defendant that he was going to take it under advisement and that he might not accept the plea. That was never announced.
You're correct. Orally, he did go through.
How's that fair, though?
Judge, it's just, arguably, its court speaks through its entries. I believe it is unfortunate. It is not really what, kind of what it was supposed to do, I think.
How is it a knowing and voluntary plea at that point if the defendant doesn't even know that the judge, is
might
thinking
withdraw
about
it later on? So that is a problem with our case here, frankly. It is, but it wasn't properly done.
The prosecution was fine with the plea, right? The prosecution believed that that was a fair plea.
So we were there, and again, the prosecuting witness was also consulted. And to kind of go back a little bit as to why this was ultimately rejected at a later date, my understanding is there was some information that came out in the PSI that kind of led towards Judge Berkowitz thinking that the facts did not fit the disorderly conduct. So it was ultimately.
But despite that, the prosecution still believed that it was
right.
fair.
And the prosecuting witness was present on the 31st, and she said she was still okay with it. So, but the judge was not, obviously, which is why we're here. And so that is, as far as that goes, on the 12th, our position is that the plea was never properly entered on the court's entries. And therefore, because it wasn't journaled on the court's entries.
So are you saying that we should ignore the transcript?
That's what the case law indicates. The court speaks through its entries. The transcript is what it is, but the judge's sheet from the 12th is not filled out. And notably, when he does come
Are
back,
there times that that there's a non-pro-tunc correction of an entry because of information that's in a transcript?
that may have been an option for the court. They ultimately decided not to. I think it was clear that he wanted to go forward with the assault charge when it came back up in January. And that brings us to January without the plea ever being officially accepted back in December. As I think Justice Krause mentioned earlier, the judge was completely within his right to reject the plea when he got that new information in the PSI. And that is ultimately what he did.
If we would disagree with that and believe that the judge did accept the plea, do you believe that Rule 32.1 permits a court sua sponte to withdraw a plea?
I do not. Looking at the case law that Mr. Epley provided, I believe he is correct. A court, I don't believe, is able to sua sponte withdraw a plea. The case law that I read from his brief, it did look a lot like it's basically meant to be a defendant's motion. So, and again, those are basically the two main points that we have in this case. It is kind of it's a very technical argument, I understand, but it's kind of where we are. And again, because that plea was never entered, the judge was within his right to reject the plea when it came back and ultimately set up for sentencing.
Thank you. Unless there's any other questions. Thank you for your argument. Attorney Epley?
Thank you, Your Honor. To address the Honorable Krause, my client, Mr. Miller, did everything that was made available to him. The judge followed the rule of criminal rule of Ohio 11C, in which making sure that the guilty plea was knowingly and voluntarily made. He understood the penalties. He understood the rights that he was giving up. If we're to now allow for the court to say, hey, you did everything that you were supposed to do, and the judge simply didn't enter the guilty plea as what everybody believed was going to happen, even though all the rules of procedure were followed, we have a very unfair justice system. My client pled guilty knowing that that's what the penalty was going to be, that he would be subjected to a 4th-degree misdemeanor. And now for the court to say, we want to take a little bit more time. I get the understanding of that, but to knowingly and to not tell my client that subjects my client to unfair treatment left and right as far as where this case is proceeding. The reason that the sentencing guideline wasn't filled out is because everybody was in agreement that the sentencing would take place on January the 14th of 2020. That's why the sentencing wasn't filled out. If we're also going to speak through the judicial entries that was made available in this case, we have a very serious problem now, because if we're not going to allow for there to be an error or, I guess, inaccurate information, if you actually look at the judge's sentencing on the date of which Mr. Miller was sentenced, Mr. Miller's name is misspelled. It's spelled with 2 A's instead of 1. So now you have a completely new defendant in this entire case. So if there's error on the name of the defendant, there's also going to be potentially error on the issue of the judge. That becomes problematic. The court, even though it speaks through its record, a transcript is a record. The court, from its own statement, said, I find you guilty. I accept your guilty plea. What more is there to do? If we're going to...
Sure. The judge's sheet in this case said guilty plea, right?
Yes, Your Honor.
Now, the argument is the back of it wasn't filled out, which is very unique to Hamilton County, right? His judge's sheets.
Correct.
Of course.
Right.
But it does say guilty plea.
It does, because Mr. Miller entered a guilty plea. He accepted what the prosecution was offering, and that is after the prosecution has now had 3 opportunities to make sure that the victim understood what the plea was going to be and what the potential penalties were going to be as a result of that. If we're going to penalize my client for doing everything knowingly and voluntarily and entering a guilty plea on that issue, of which everybody is in agreement with, and then to wait for the court to say, I need more information before I make that decision, that either should have been put onto the record so that everybody understands what's going forward, that the January 14th may not become an ultimate sentence, but may become a change by the court as to what that plea is going to entail. And at that point, I could have prepared Mr. Miller and say, the court may do this. But when you use the word accept, which is the legal terminology of accept, and now you have found him guilty, that becomes an issue under the rule saying you have now adopted a guilty finding. The transcript is clear about that. The judge's sheet is clear about that. And at which point in time, it's only appropriate for the court under the rules, under 32, to now proceed to sentencing, which is what was set up on January 14th. It was continued for restitution issues on January 31st. And now all of a sudden we have a new issue come on July 28th with an additional plea. You have 2 guilty findings, which now issues on the issue of double jeopardy.
Thank you both for your arguments this morning.
Thank you, Your Honors. I appreciate your time.
Thank you, Your Honors.
Thank you. You both did a great job.
Thank
We're
you,
going
Your
to take the matter under submission and issue a timely decision, and I wish you a wonderful afternoon.
Very good. Thank you so much for your time, Your Honor. Good.
Thank you.
Thank you.
Good morning.
Morning.
Morning, Your
We
Honors.
now have- Good morning. We now have case number C19-0654, State of Ohio versus Ray Sean Gatewood. If attorneys can please identify themselves and their readiness to proceed.
Good morning, Your Honors. Chris Degieski on behalf of defendant appellant Rayshawn Gatewood, ready to proceed.
Good morning,
Good
Your Honors.
morning.
Keith Sauter on behalf of the State of Ohio, Appealable, ready to proceed.
Good morning. Attorney Giesky, would you like to reserve any time?
I would like to reserve 3 minutes, Your Honor. Thank you.
3 minutes, whenever you're ready.
Okay, may it please the court, Mr. Sauter. This is a case where a working man, a family man, did everything right to the best of his ability. And what started as a family confrontation turned potentially lethal in mere seconds. Nonetheless, Rayshawn's felonious assault and weapons under convictions were obtained unlawfully. And first, I would like to start with the first assignment of error, wherein we argue that a juvenile adjudication, in this case, the state failed to prove the juvenile adjudication that served as the disability for the weapons under conviction.
So this is really just a sufficiency argument, right?
It is. It's a sufficiency argument. The reason I set it out separately is for the constitutional implications, which I felt kind of elevated it above a mere sufficiency argument. But that is the basis. You're correct, Your Honor. So the first reason that we advanced was that the state failed to prove that the offense of adjudication, not conviction, if I say conviction, the offense of adjudication was actually a disability creating offense. And to Rayshawn's memory, he had pled admit to a lesser offense. And problematically, the record introduced, the judgment entry, says that the complaint was for felonious assault, but then next to the admit entry, it says nothing. And as you know, as someone in the prior case just said, the court speaks through its journal, and that is an omission that we cannot then imply that.
Can I ask a question about the entry? Is this one entry, judicial entry of adjudication? Is it one piece of paper that has felonious assault on it and then changed plea to admit on the same paper? Or are you saying there's 2 different ones?
It kind of looks like, so what I'm looking at here from 99 reminds me of the municipal court judges sheets we see now. So I think those are, actually separate entries, but this is all the latest sheet, the most recent sheet that all of the rulings would be on in the disposition of this case. And I know they've changed, their forms dramatically since 99. Now when there's a box that is checked when someone actually pleads to a lesser than admit in JCMS, and that just wasn't the case back in 1999. So we don't actually know.
The court clerk testified that it was, that this meant that he pled to the felonious assault, right? There was a court clerk that testified.
She did attempt to testify to that, but the problem with that is that she had only been the deputy clerk since 2016, and she admitted on cross that she could not testify to the practices back in 1999. So even though it says felonious assault next to the word complaint on the rap sheet, she admitted that she couldn't attest to the fact that that's what he had ended up admitting to. And the reason being, that in juvenile court, you know, it's unlike adult court, the actual what they admit to doesn't matter for anything other than sentencing because they're not actually convicted. So the offense underlying it is just doesn't hold the same weight as it does in adult court. So it kind of makes sense why, if record keeping was looser back in 1999, why it didn't matter as much.
But where I get a little tripped up on your argument is we're looking at sufficiency, and you know, this was all presented to the jury. They chose to believe that the court clerk and this is the way things work. And so I don't know how we get around
Well,
sufficiency.
well, choosing to believe the court clerk would be manifest weight, so that's not really the consideration for this. And again, that's why I set it out in the first assignment of error separately, was because of the implications upon it rises above sufficiency when you're looking at due process, and then tangentially the right to bear arms. And so that's why it's a whole separate analysis when I'm speaking of the constitutional. It's a different level of scrutiny than just the sufficiency standard, which I didn't cite as a standard of review here because that's not exactly what we're looking at under the first assignment of error. It does implicate it. It does tie into the sufficiency assignment of error 4.
It seems like there would be no way for the state to even be able to prove that's that.
Can you repeat that? I'm sorry.
How would the state be able to prove this conviction?
Well,
this is the paperwork that exists.
It is, and that's the omissions. So there should have been a fingerprint card, and it was lost. The fact that the record keeping was possibly looser back then, the fact that the fingerprints were lost, those omissions, you know, the burden is on the state, and those omissions in the paperwork that have since been rectified in the system, tightening up how it's controlled, but those shouldn't be held against my client who does not hold the burden of proof.
Ms.
So-
Gieseke, I'm drawing on my recollection back from the 90s, but I seem to recall that at some point, now your client was 12 years old at the time, that there was a prohibition to fingerprinting juveniles. Did that come out anywhere in the record or through the testimony?
It didn't, Judge. The only testimony, 1 second. Ms. Davis, the deputy clerk, testified that there is supposed to be a fingerprint card put into a record when a juvenile is adjudicated delinquent in a felonious assault case. So that's
Okay.
the testimony we have in the record for this case.
Okay, thank you.
So that's our first argument on this, but there are a couple of the layers that even if, let's presume for the sake of argument that the offense of adjudication was a disability creating offense. The problem is that the state failed to show that. We'll move on to the sealing as a matter of law, because the judgment entry does cite the old statute from 1999, and that would be 2151-358. And that statute provided that under C1B, that 2 years after someone was adjudicated, that a record would be sealed automatically, and then if it wasn't, that had to be entered of record. So it was discretionary, but if it wasn't done, the statute provided that the juvenile offender had to be notified. And again, the court speaks through its journal. We have no entry on that what looks like a judge's sheet saying that Ray Sean was notified that that it was not sealed by operation of law. So we can presume
it's a really interesting argument, but this wasn't raised below or argued below, right?
I don't recall. I'm sorry, Your Honor.
Because it sounded like the defense was that he pled to a lesser charge and he was never under a disability, not that he pled to that charge and it was sealed.
That may have been, you may be correct. I don't recall if I found that commemorated in the record. So you may be correct. But as you know, this court can, well, I won't go there, but that could be correct. It could have been waived. And I apologize, I didn't double check on that. Another problem is that we're not totally positive that, you know, when I look at the record of the judgment entry, we don't know that the juveniles are, in fact, notified that this weapons disability is going to, when they plead, admit, We don't know if they're notified this is going to follow them through their adult life, which again has potentially lifelong weapons Second Amendment implications. So we don't know that Rayshawn was informed. That would I guess be a challenge to the plea of admit, but also just a general Second Amendment challenge that the Carnes decision left open. And Carnes did come out of this court, and Carnes was upheld, but it was a divided court with three visiting justices or three visiting judges, and Chief Justice O'Connor had some good points about how the differentiating Bodie and Hand, where they say a juvenile adjudication cannot enhance an adult penalty, is not really different than saying a juvenile adjudication shouldn't follow a kid into adulthood and serve as a weapons disability. So that was left open. And we also, I just urge this court to revisit that issue and really think about it hard, because, with Justices Donnelly, Stewart, and Bruner on the court, and then you have O'Connor's dissent, there could be this issue could be revisited. I think that the juvenile, you've heard it time and time again, especially from our office, that the juvenile system is just different. And that the wisdom of allowing this to serve as something that infringes upon someone's Second Amendment rights throughout their adult life, that the due process and Second Amendment arguments just are not there. Justifications are not there. So even, let me see, I'm going to pass that up. I would like to actually move on, if there are no further questions on that, to the evidentiary errors plaguing the case, because I think that these errors cumulatively, as we argue, do require a new trial on both charges. Number one, the admission of, so Rayshawn was kind of painted as, this gun-toting vigilante, which is kind of laughable. He's an ice cream truck driver, he goes to bad neighborhoods, yes, but he's this slight man who voluntarily takes these treats into neighborhoods where there's, downtrodden, dangerous, yes, but he got it. These guns, the Ruger, the Glock, and the bulletproof vest kind of relates, were not used in this offense. In this way, this case is right on point with the Thomas case out of the Ohio Supreme Court with the knives. And yes, arguably any gun can be relevant to the weapons under charge, but they only needed one gun for that charge, and he admitted to using and possessing the Taurus. So the other guns become extraneous and prejudicial at that point. And
did defense counsel try to keep those out at all?
There was. I don't recall if there was a pre-trial motion, but I know I did read the transcript, and counsel did object at trial. Yes.
At trial.
Yes. So I don't recall if it was a pre-trial, but the Ruger, the Glock, and the vest, yes, all three counsel did try to keep out at trial. And for this very reason, it looks bad. It makes it look like he's armed to the teeth, and that he did go over armed to the teeth when there weren't even any allegations that he had these other guns on him when he went to just have the discussion with Dante. So they really are just propensity evidence that are, Thomas is directly on point. They had no permissible purpose under 404B, and they should have been excluded under 403A, mandatory exclusion.
Ms. Giesky, let me ask you this question on concerning the weapons under disability count. There are three forfeiture specifications, one for each of the firearms that were retrieved. And when you look at count 3, the weapons under disability, it just says firearm. It doesn't say Taurus. It doesn't say this. But there was no finding by the jury or the finder of fact concerning the forfeiture of those three firearms. I know that the one was forfeited that was used in the act, but how would you address that? It's my understanding that the court, if it so desired, could have had the jury determine whether those firearms ought to have been forfeited. Does that question make sense? If the firearms are related to count 3, it seems to me they would be admissible in evidence.
Arguably, they would have been. Again, the relevance threshold is super low. So arguably, yes, they would be relevant to the forfeiture specs. But, just because they're relevant, I would still argue that under the second and third prongs of the Williams analysis, so the evidentiary analysis, that they shouldn't have come in, and that the state can pursue a civil forfeiture action entirely separate from the forfeiture specs. So that would be the better practice if you want to get these other guns out of his hands and not.
I'm sorry, but it was attached to the indictment. Those specs, I mean, it's up to the state how they wish to proceed. They certainly could proceed civilly, but at least in criminal matters, it's been my experience that they attach the forfeiture to the related count.
They do, but we would argue that the charging instrument, itself doesn't render evidence admissible, arguably, So aside
Dr.
from,
Leesky, unless there's any other questions, I'm going to reserve you 3 minutes.
okay, I'll hold off then. Thank you, Judge.
Okay, thank you. Good morning.
Morning, Your Honors. May it please the court. As for the first assignment of error, I think the court in its questioning has addressed the points that I wanted to make. There were several components to piecing this together, making sure that the adjudication was tied to this defendant. First of all was the testimony of Officer Rackley, who indicated that this was the same person. Introduced into evidence was the complaint, the delinquency complaint, which indicated that the underlying offense, if he were an adult, would have been felonious assault. On the entry of adjudication, it says only admit. There's no indication that there was any reduction of the charges. And Ms. Davis at page 471 of the transcript clearly stated that if there had been a reduction in the level of the offense or in the charges that underlying the adjudication, it would have been noted in the record. So I think in terms of a sufficiency argument, I think the state presented ample evidence that the adjudication was for felonious assault. It's an felony offensive violence that created the disability in this case. As for the ceiling, I would first note that the court is correct that the issue was not raised below in terms of the alleged automatic sealing of the record. I would indicate that a sealing of the record would not be tantamount to a relief from the disability in any case. In adult court, it might, because under RC 295333, there's a restoration of rights provision that doesn't occur in RC chapter 2151, which relates to the expungement and sealing of juvenile records. So unless the court has any questions about the first assignment of error, I would like to move on to what Ms. Gieske has characterized as the other acts evidence. I think that the problem here is that it really wasn't other acts. Thomas is completely distinguishable. In Thomas, there was no indication that the knives had any relation at all to the offense. In this case, you have a defendant who has learned that there are allegations that his daughter has been molested by the victim in this case. And evidence is that he has a carload of weapons. He has a bulletproof vest in his car. And that's certainly relevant to his state of mind as what he's doing when he's going over there. It's as already noted, the guns were part of the res gestae of this case. They were because of the weapons under disability charge.
Doesn't that just try to paint him as a violent person?
Well,
I mean, he already admitted that he had the gun, he shot the one gun, and then to introduce the evidence of the other guns and a bulletproof vest. I mean, doesn't that just make him look like a violent person?
And I think under certain circumstances it could, but when I recently reread the transcript of this case, and that's not something that's exploited by the prosecution even a little bit.
That goes a harmless error, right?
Well, I'd say it's harmless at best, because I think that it was relevant to his state of mind when he went there. He wasn't going into a bad neighborhood to sell ice cream. He wasn't in his ice cream truck. What he was going to do was going to confront somebody who he believed had molested his daughter. So I think it was certainly relevant. As Ms. Gieske has conceded, relevancy is a very low threshold. I think it was certainly met in this case, and any problems that might have been caused by the so-called propensity evidence, pardon me, was cured with the jury instructions. And I don't think that there was any invitation for a jury to make an improper inference in this case.
You don't even think that the bulletproof vest was a little much?
It might, it's arguably a bit much, and I understand that. I understand what the implications are of showing that he had that in his car. But I think in the context of the entire proceeding, it was harmless. If error at all, it was harmless beyond a reasonable doubt. I have no further comments about the first two assignments of error. Ms. Gieseke didn't address the third and the fourth, and unless the court has questions about that, I will similarly gloss over it myself.
Thank you.
I have nothing further.
Thank you. Thank you. Attorney Gieseke?
Thank you, Your Honor. Briefly with the first assignment of error, Ms. Davis did testify that, I'm sorry, one second. She indicated she was unable to testify to practices from 1999 or the normal course of business back then because she had only been chief deputy since 2016. So again, her testimony, Rackley's testimony, the juvenile complaint, none of these things actually solidify what Rayshawn was adjudicated of. And it is a high burden. So we would just argue that burden was not met, and that it does have both sufficiency and constitutional right implications. With the evidentiary errors, counsel's intro to Thomas was that there are no indication the knives had any relation to the offense in Thomas. That's exactly the same rationale here. There's no indication that the Taurus, the Glock, or the bulletproof vest were in any way related to the instant offense. In fact, everyone said it didn't look like he had the vest on underneath because it's bulky. The other two weapons, I think, were somewhere in the car, but there's no evidence he had them on him. They're absolutely not related. The only way they're related is to make it look like he's a man who's armed to the teeth, as counsel called him, a man with a carload of weapons. That is propensity evidence. That is meant to paint him as a violent, gun-toting vigilante.
How is this not harmless, though? Because the state's arguing that this really wasn't dwelled upon. I read the closing argument. It wasn't really mentioned that much. So how is this not harmless?
Well, when we look at what's funny is that when they were arguing on a recorded sidebar, I'm sorry, one second. The judge even said that the guns in the vest didn't prove or disprove any fact issue, and they made Rayshawn look like, quote, a gun-toting vigilante. And then curiously, the judge then said, so that's the impression that the court got from this, but said that it was relevant because he admitted he had one gun and shot Dante, which I think that reasoning was flawed. And the reason it wasn't harmless was because the entire defense centered around him using force in a subjectively reasonable manner in self-defense. So making it look like he had all these guns, armed to the teeth, walking down the stairs, putting on gloves like out of a movie, makes it look like he is this cold, calculated, desperado, and countered his entire defense. So it wasn't harmless. It was highly prejudicial. And if you excise all of this weapons evidence, we think that there's a good chance that it could have had a different result, especially if, I know it's not quite proper to consider the after effect comments from the motion for new trial, but the jury did say they believed him, and then they convicted him anyway.
I know it's not proper. They said what?
So the jury did say they believed that he got spooked, that they thought he was a sympathetic figure, and but then at the end of the day, he did shoot someone. Well, then that means they didn't perform the burden shift properly, that the burden, the new standard was in effect by then. This is the last assignment of error. So they should have, that means he met his preponderance standard, and they should have shifted the burden to the state to prove that he didn't use reasonable self-defense in beyond a reasonable doubt. And their comments proved that they didn't do that. And I'm not quite sure if you can consider any of that or not in the sufficiency analysis. That's why I didn't want to emphasize it.
Ms. Gieseke, could I ask you another question about the guns?
Yes.
If the state had so desired, they have 3 guns, they could have charged him with 3 separate counts of weapons under disability. Do you agree or disagree with that?
Yes, I think
they chose not to, but
they could have tried to. The
Yeah,
Glock may
they
not have
said
stuck at grand jury, but they could have tried. Yeah.
okay.
Yes. If there are no, well, and one other point I'd like to make, just going to the sufficiency is, the molestation allegations, everyone assumes, or you can't presume that by virtue of the allegations, he was a man hell-bent on revenge going over there. You know, there's a chance that maybe this daughter is less than truthful and they didn't actually believe her. You know, they went over just to sort it out. That's what the testimony of Rayshawn and Antoinette suggested, that they were just going to go get to the bottom of this, you know, and that really this just turned in a flash and it was not pre-planned, despite what the state painted him as. This was a terrible, tragic, you know, misstep when he was thinking he had to defend himself, and it just went awry very quickly. If there are no further questions, we would just ask that the court reverse both of Mr. Gatewood's convictions and order a new trial.
Thank you both for your arguments this morning.
Thank
We
you.
will take the matter under submission, issue a timely decision, and have a wonderful afternoon.
Thank you, Your Honor, you as well.
Take care.
Bye-bye.